Welcome everyone to the webinar today. Today we're going to be talking about Handbook 101. So the agenda for today is, what is an employee handbook? Why is it important? What should be in the handbook? What shouldn't be in the handbook? And how myHRcounsel can help. So those are all important questions when you are thinking about an employee handbook. So what is an employee handbook? An employee handbook is a thorough but concise guide to the do's and don'ts of your organization, as well as answers to legal questions. Employees need to know things like how many rest breaks they'll get or when payday is, and employees should know who to contact if their paycheck is short or if they're being harassed or want to view their personnel files. So those are all things that would be part of the employer-employee relationship. The most important part of the guide to the employer-employee relationship is establishing at-will employment. And you want to make sure that either party knows they can separate from the employment at any time, with or without cause and with or without notice. Handbooks should contain a code of conduct or work rules so that you can stand by a policy violation if an employee is terminated. You want to make sure your employees know the rules from day one and are not caught off guard when they're disciplined or terminated for no apparent reason. The handbook is kind of like a give and take. What you expect for your employees and what your employees can expect from you. You need to have an at-will disciplinary policy that allows you to skip a step at any time. Do not lock yourself into having a handbook to complete each step before you suspend and terminate. Your handbook should state that the discipline is in your discretion and any and all steps can be taken even on a first offense. Benefits for the purpose of a handbook include paid holidays, vacation, PTO, paid sick leave, if you have volunteer time off, the rate at which these things accrue, maximum usage, carryover, all parts of these benefits should be in the handbook. So why is a handbook important? So employees will follow the rules when they are told what they are. If you don't tell your employees what the rules are and try an approach where you just discipline employees when they do something you don't like, you will have employees trying to evade discipline, not employees being properly and productively. The handbook makes expectations very clear, such as things like the social media section that states that there is no expectation of privacy in any computer use on the job. The employee is more likely to trust the employer when they know that things like that their internet activity is being monitored. Again, when employees know what to do and what not to do and don't just get hit with discipline out of the blue, they are more likely to obey the rules and avoid disciplinary issues for you. And you can trust that they know the rules and aren't going to cause a retention problem for you by just going freestyle. Employees love to search for what you can and can't do on the internet. When you give your employees an employee handbook that has been drafted by attorneys that is legally compliant, you're telling them that your information is legally compliant and that something from Google is not going to apply to employee behavior or overtime or paid time off or anything like that. Protection in case of a lawsuit is a big one. If you are sued by an employee who claims they were terminated for an illegal reason, such as discrimination or retaliation, and you say, no, I terminated them because they violated this policy, and you have no written policy to show or way to prove that the employee was ever informed about it, that's going to be a point on the employee side. Also, if your handbook is not drafted by an attorney and it is 200 pages long, and the employee says, there's no way I could have read through that whole thing and found that policy, a jury of that person's peers is also thinking about how they couldn't read a 200-page document. Having a signed acknowledgement shows that the employee agreed to abide by your code of conduct, and when he or she broke it, you terminated that person in accordance with the handbook that they acknowledged reading. You can also avoid wage and hour claims by laying out your overtime policy. If you have an employee who works overtime without your permission, you can't refuse to pay that employee. But if your handbook says overtime without permission is a violation of policy, your employee knows the rules and can't claim a wage and hour violation when you discipline them for working overtime without permission. So what should be in a handbook? You must first establish that you are an equal opportunity employer and that you do not make employment decisions based on membership in a protected class. Make sure you list all of the protected classes that apply to you. If an employee goes to the EEOC with a complaint, the first thing you want to send in is that page of your handbook affirming that you are an equal opportunity employer and that is officially established in the document that represents you as the employer. Anti-discrimination, anti-harassment policies let employees know both what they are not allowed to do if they are a potential harasser and what they do not have to tolerate if they are a victim or if something happens. Make sure you have a very clear reporting policy so that employees know how to report discrimination and harassment. You should have a provision about the Americans with Disabilities Act. So if you have an employee who is having a hard time performing the essential functions of their job due to a disability, they know that there is assistance available and they know how to request it. Wage and hour information, like I said, when is payday, what is the pay period. This is evidence if an employee tries to make a wage claim saying they weren't paid on time. It's all in your handbook, and you can show that you did follow your own handbook. Previously mentioned overtime without permission, whether employees get breaks either by state law or employer choice if there's no state law requirement, how long the breaks are, which breaks are paid, which are unpaid, lactation breaks. The laws are different in every state. State and city mandated paid sick leave must be in the handbook by law. Employees must get notice of these policies at the time of hire. They then have to know all about your policy, your PTO policy or vacation policy, because the law says that whatever you say about vacation and PTO to your employees must be followed no matter what. So if you are combining state or local paid sick leave with your own PTO policy, make sure your policy is compliant to cover the PSL law. You must go back and make sure that the handbook supersedes all other documents, written or oral, or an employee could go back and say that the signed offer letter was a contract and the handbook doesn't say anything to change that. At-will employment must be preserved, and you must reserve the right as the employer to change any part of the handbook at any time in your sole discretion for any reason or no reason. And like I said, most importantly, the handbook must have a signed acknowledgement. So a code of conduct as far as employee handbooks go, the list should be, note that it is illustrative, not exhaustive. You still want to be able to discipline someone for something inappropriate they do that might not be on a list that cannot be infinite. Make clear behavior that would be totally unacceptable to you. Use expectations. Don't just focus on the negative. Just punitive uh, information doesn't build trust between you and the employee. You want to know, you want them to know the X company way and company culture. So talk about the good behavior that you would like to see that's going to make the work relationship a good one. Make sure that, like I said, if you have a progressive disciplinary policy, it gives you the right to skip steps and administer any and all form of discipline for any offense, even a first offense. Do not lock yourself into a progressive policy that requires you to give a verbal warning to someone caught stealing from the till. Remember, it is at will employment. You may change the terms and conditions at any time. Make it clear that you choose the discipline no matter what. And you can come back next week to find out how changes to the law may make your code of conduct non-compliant and require an overhaul to keep your code of conduct in legal compliance. And we'll talk about that next week. What shouldn't be in a handbook, how to answer the phone, where to park, that can be discussed during training. Instructions on representing the company if you have a guest services policy or you expect employees to always smile and say thank you. That should be taught during training and part of a training manual. With regard to benefits, employees should receive an SPD detailing eligibility requirements and benefits. If you have more than one benefit plan, employees can receive a benefits manual, but there's no need to put in the employee handbook that employees are eligible for dental insurance or anything like that. Come back next week to find out what may be lurking in your handbook that no longer complies with the law. Also, you should not customize with rules that are illegal on their face, such as English speaking only or employments. Employees must use pronouns that match the employee's ID or anything illegal, obviously, like that. Safety industry and job specific needs need to be taught with respect to the hazards that may come up in the course of the employee's job. But you don't want the handbook and the safety manual to distract from each other. Safety information is also not legal information that should be in the handbook. Yes, I realize that OSHA is a law, but they want safety information as clear as possible and not wedged in the middle of a handbook where it's going to get lost. Again, where to park, where to smoke, what to wear on spirit days, how to use the Slack channel. All of this can be covered at training. Any specifics about operations, where things are located, how to obtain supplies, any operational information, and not legal information that goes in an employee handbook should be distributed some other way. So how myHRcounsel can help? You can see here all of the benefits that come with myHRcounsel drafting your employee handbook. Come back next week to talk about continued compliance. That 2-year-old handbook that you got from your human resources advisors is useless now and also illegal without some upgrading and revision. Now, a handbook from a private law firm could cost you $5,000. And at that price, you don't want to have it updated annually, even though you need to have it updated annually. You could likely get an entire year of Ask HR, including the handbook and unlimited legal advice and documents for less than you would pay for the one handbook from a law firm and an annual update to your handbook is always included in your Ask HR subscription. And the best practices handbook is included with your Ask HR subscription. There is no additional charge for the best practices handbook. If it doesn't cover enough to meet your needs, there's always Employee Handbook Plus, which is an upgrade option to cover more ground if you need it. So do you have a compliant employee handbook? Start the process of bringing one to your organization today. There is a very strong possibility that your handbook is outdated and non-compliant. And if you are a myHRcounsel client, please open a handbook ticket requesting an employee handbook or a review of your last year's employee handbook. If you are not a client and you need an employee handbook based on what we talked about today, please go to or send an email to info@myhrcounsel.com or go to myhrcounsel.com for information on how to get a legally compliant handbook. So thank you all for participating in the webinar today. I appreciate your attendance, and I hope you all enjoy the rest of your day.